Hello and Happy New Year. In this series of short videos, members of the commercial IP and technology team at Travers Smith will be looking at where we are in the Brexit process 1 year on from the end of the transition period and the UK's effective exit from the EU. We'll provide practical tips on what businesses should be thinking about in relation to Brexit over the course of 2022 and beyond. With the imposition of new border requirements on EU imports with effect from the 1st of January, and supply chains continuing to face extraordinary strains, it seems inevitable that we should be returning to this subject now, and 2022 promises to be another interesting and challenging year in the Brexit narrative, but also perhaps a year in which we may start to get a better sense of the future direction of travel. To give you a flavour of what's coming up in the series, we'll be looking at the impact of Brexit on the following: dispute resolution, contracts, trade in services and data transfers, trade in goods, retained EU law, trade agreements, and business travel to the EU. And in this first introductory video in the series, I'll be looking briefly at 2 points in particular. Firstly, where have we got to in the Brexit process, and trying to answer the question, is Brexit done yet? And secondly, what can we expect to happen to UK law and regulation now that the government has got what it wanted and is able to chart its own reformist course away from the EU's direct influence? So firstly, this question of whether Brexit is done yet. Now, of course, we left the EU officially at the end of January 2020, but very little changed at that point because we entered the transition period during which EU law continued to apply in the UK, and the UK continued to be treated as if it was still a member of the EU. Following the end of the transition period, we left the single market and the customs union, and we moved to a trading relationship which was governed by the new Trade and Cooperation Agreement, or the TCA. But that agreement left a number of important matters unresolved. For example, there was the question of the exchange of personal data with the EU, where the TCA helpfully provided for a grace period of up to 6 months. That time enabled the European Commission to complete the process it needed to issue an adequacy decision in respect of the UK, which it did in June 2021. And this is one of the topics that we'll come back to later in the series. So clearly considerable progress has been made in terms of the government's commitment to get Brexit done, but there remains a fair amount of unfinished business. To give 2 examples of this, on financial services, although a memorandum of understanding has been agreed with the EU, it had been hoped that the EU could be persuaded to grant equivalence for at least a limited range of UK financial services, which would mitigate some of the damage from the loss of passporting rights. But progress to date has been limited, and the UK government now appears to be concentrating on possible reforms to UK regulation rather than damage limitation with the EU. And on state aid, one of the sticking points in negotiating the TCA was the EU's insistence that the UK should maintain an effective regime for control of state subsidies. But national legislation for that regime still isn't in place, so as a temporary measure, the UK has given the TCA's state aid provisions a form of direct effect. That is unsustainable over the longer term, and the government is hoping to remedy this with the Subsidy Control Bill, which is currently before Parliament, but it may still be some time before this new law actually comes into force. So really the key message here is that Brexit is not a single event, but it is better seen as a process that will need to be worked out over many years. And sticking with this notion of unfinished business, let's turn now to the second topic I wanted to cover in this video, that of regulatory reform. A key theme of the government's stated approach to regulatory reform is that it wants to take advantage of the sovereignty it regained from the EU to do things differently after Brexit. In 2021, the government published a report from a group called the Task Force on Innovation, Growth and Regulatory Reform, or TIGR for short, which contained a whole series of recommendations on possible reforms. The government has since promised to take quite a few of these forward, and I'll pick out some highlights shortly. But before I do that, it's worth noting that the TIGR report advocates taking regulation in the direction of what it calls a more common law approach. To the extent that this means greater flexibility and pragmatism, then it's likely to be welcomed by many businesses. But the TIGR report and a subsequent government consultation on better regulation also advocate an approach to regulation which relies more heavily on broad principles, with regulators rather than Parliament taking decisions on detailed implementation. They contrast this with what they see as an overly detailed and prescriptive approach to regulation by the EU. It's not too hard to think of examples of EU law where that criticism would be justified, but many English lawyers would say that an equally common frustration with EU law, both legislation and case law, is that it often sets out broad general principles without providing sufficient detail on how they should be interpreted, leaving businesses and indeed regulators uncertain about how to comply with or enforce the relevant law. There may be a danger that in shifting too much towards a principles-based approach, you lose the benefit of legal certainty, which many would regard as one of the benefits of a common law approach. So it's worth keeping an eye out for the government's response to its better regulation consultation, because this may prove influential in setting the overall direction of travel for the remainder of this Parliament and beyond. Turning to concrete reform initiatives, there isn't time in this video to cover them all, and the thorny issue of reforms to data protection legislation we'll be returning to later in the series. So I'm just going to highlight 5 in particular for now. Whilst a number of these proposed changes fit the government's post-Brexit narrative that having left the EU, we can regulate in a smarter, more targeted and light touch manner, it's interesting to note that the first 2 of these do not, because they actually signify more onerous regulation, not less. So firstly, consumer protection reform. There are big changes afoot here which reflect the direction of travel in the EU. The government is proposing to give regulators such as the Competition and Markets Authority the power to take infringement decisions and impose fines directly without having to go to court. Assuming this goes ahead, it will raise the stakes considerably for consumer-facing businesses because they will face fines similar to those which they face in relation to breaches of competition law. Second is tougher regulation of tech. The government is also taking a much tougher approach to the regulation of big tech in particular. The 2 developments I'd highlight here are the Online Harms Bill and the new Digital Markets Unit that's been set up within the CMA to look specifically at competition issues relating to major tech platforms. The Brexit-related point here is that, like the reforms to consumer regulation that I just mentioned, the EU is pursuing similar initiatives, notably with its Digital Markets Act, but the UK government would probably argue that its approach is more flexible and less prescriptive. Whether this will be sufficient to make the UK more attractive as a home for tech businesses of the future, as the government hopes, remains to be seen. Thirdly, is more flexible financial services regulation. One of the most important recommendations of the Tigger report was that the government should allow pension and insurance funds to invest in a wider range of assets. The idea is that this increased flexibility will give savers better returns and boost growth in the UK. It would seem to be an area where leaving the EU could allow the UK to pursue an approach to its benefit, but a careful balance will need to be struck between providing extra flexibility and avoiding excessive risks for investors. Fourth is the exhaustion of IP rights. The government's now consulting on whether the UK should move to a system of international exhaustion, which is not something that it could have done inside the EU. There are fears that if these proposals go ahead, some brand holders may find themselves being undercut by cheap imports from less wealthy countries where similar products would be available at a lower price. The main counter-arguments are that consumers benefit from lower prices, and a number of other major trading countries such as Japan and the US operate international exhaustion regimes to varying extents. And fifthly and finally, public procurement. EU rules on public procurement have long been criticised for being too prescriptive and inflexible. Outside the EU, the government has scope to make changes in this area, and we have now received its preliminary response to a consultation that closed in March 2021. This signifies that reforming legislation will now be brought forward when parliamentary time allows, with the expectation that this will be implemented in 2023 after giving organisations 6 months notice of go live to allow them to prepare for the new regime. But those hoping for contracting authorities to be given scope to act much more like the private sector does when it's tendering for suppliers may be disappointed, because public procurement is a good example of an area where, despite Brexit, government can't simply start again with a blank sheet of paper. In particular, it is subject to significant constraints on its freedom to act under both the TCA and the WTO Government Procurement Agreement. So that's just a flavour of where we are on Brexit and what is to come. Do check out our subsequent videos in this series, and please get in touch with us if you need any advice on any of the matters we cover. Thanks for watching.